Evidence Act, which equally highlights this entitlement to bail, and it lists quite a number of that bail is an entitlement. So amongst the reasons why a person can be denied bail is if there is a reasonable suspicion that that person can actually, go on to commit further offenses. The release of that person can actually destabilize peace and order. If there is evidence that if that person is granted bail or is released on bail, that person can abscond. So you have that Criminal Procedure and Evidence Act laying in the basics insofar as the issue of bail is concerned. So in terms of it being in line with the Constitution, there is no issue because you've got your section 117, which was amended so that it actually falls in line with the Constitution. So there is no problem with that act. There is no problem with that provision insofar as the right to be released on bail is concerned. So the issue now lies with that discretion that I have indicated to you, to say the court that will preside over a matter has some sort of discretion to actually determine what could be regarded as compelling reasons for the purpose of bail. This is where you then see the bail system itself being abused, because that discretion now is exercised, from my own observation, depending on who is appearing before the court, depending on where the person is actually coming from. That discretion is not being exercised in a manner that is fair or that is consistent. So that's where you now have this bail system now being abused in one way or the other. Now, when you look at Job Sikhala, I'll make reference to Job Sikhala more because there are so many issues about him to be discussed, and I think I know a little bit, so I think I'll emphasize. But when I make reference to Job Sikhala, I'll still be referring to the others. Nyatsime 15. Just for you to see how this compelling reasons aspect has been abused by the system. We have it on record, and it's factual, that Job Sikhala has been arrested at least 70 times. This is on record. If you look at it, even if you go back to 2003, Job Sikhala was arrested together with Gabriel Shumba. Job Sikhala has been charged with almost every crime in terms of the criminal code. You talk of being charged in terms of POSA, which was recently changed to more or no material difference, still same thing. He's been charged with murder. Job Sikhala has been charged with treason. He has been charged with assault. Surprisingly, Job Sikhala has also been charged with rape. If you didn't know, he was charged with rape. Sometimes in 2012, he was charged with rape. He was charged with incitement. He was charged with obstruction. Any crime that you can think of. I think Job Sikhala has been charged with it. But when you look at it, before the so-called Second Republic, I don't know if people will agree with me. Without sanitizing, what Robert Mugabe did. We had our issues with Robert Mugabe insofar as the issues of the law are concerned. But what I picked from Robert Mugabe's era is that Robert Mugabe never, if I may use that word, tempered with the discretion of the judicial system. He tried to maintain the integrity of the judicial system. And I think that is why you can observe that before the so-called Second Republic, Job Sikhala was arrested for several times. But during those times, he never spent the time that he has spent in prison under the current regime. Because Mugabe did not then went as far as interfering with the bail system. He did not go as far as interfering with discretion to ascertain the legal grounds to say, are there compelling reasons for detaining? That's why even as much as he was arrested several times, you'd still go to court and still be granted bail. You still go to court and the court will say, okay, you have not been convicted of any offense that we know. You are still innocent in the eyes of the law, and you're still entitled to be released on bail. Even if the cases will go on to trial, and in some instances you'll be discharged, in some instances, you'll be acquitted at the end of the trial. Robert Mugabe did not tamper with the judicial system. There was no, what I'll try to call, a direct interference with the judicial system. Allowed the judiciary, in fact, to do their job. That's why even before that, our judgments, the Zimbabwean judgments, were actually quoted in some jurisdiction as authority, as reference to say, but now we've got a problem. Under the Second Republic, we've actually observed that there's been serious interference with the judiciary. There's been serious interfering with that discretion. There's been direct interference insofar as the decision of the magistrate, insofar as ascertaining the aspect of there being compelling reasons. In fact, we've observed that the judiciary is now being used, in fact, as an organ for the purpose of fighting political battles. Now, I say so for the following reasons. After 2017, you can tell that Job Sikhala has been arrested so many times after 2017. And at this rate, I'm quite sure that if we give it 5 or 6 more years, Job Sikhala will be arrested 120 times if they don't detain him at jail forever. They'll do that. So, but what you've actually observed, what I've observed, is that there's been direct interference to such an extent that the decisions that are now coming from a court, you don't need to be a lawyer for you to know that this is not legal. You don't need to be a lawyer for you to conclude that this decision is not based on law. It's actually based on something else. You don't need to be a lawyer to actually make a conclusion that there is a reasonable possibility that this judgment could not even have been written in a court of law, but could have been written elsewhere. We have signs. We have seen that. It has been happening. And I can tell you that there has been interference, and I say so because of the following. Particularly making reference to the case of Job Sikhala. Legally, if you look at it, we are dealing with a person who, like what I've said earlier on, has not been arrested once, but several times. At all material times, Job Sikhala appeared in court. At all material times, Job Sikhala did not flee. And as we speak right now, he has his passport at the clerk of court. He does not have any travel document. He has appeared in court and he has been continuously been acquitted at the courts of law. Remember, the purpose of being released on bail is to ensure that you attend trial. No other purpose. Purpose is simply to ensure that you attend trial. If there are issues of interference, the law is clear. The state must prove that there is evidence of previous interference with witnesses. If there are allegations of disturbing peace, the state must prove that you were once convicted of, disturbing or causing violence in any way, and you must have actually been convicted. There is no evidence on record to suggest that Job Sikhala was at any point in time convicted. So you now have a situation where a person who has been arrested 68 times, released on bail, appeared in court, being tried and being acquitted, you detain him for the 70th time that has been arrested, saying that we fear that you'll be you cause noise, you do all sorts of things. Why did he not do that the previous times that he has been arrested. Remember, there are records showing that this person has actually been complying with certain conditions. So, you know, we now have a situation where we have judgments that are now particularly targeting members of certain opposition parties. And these judgments are actually being crafted in a manner, Yekuti one way or the other, they'll find somewhere, hold on to that something and say, okay, because of this, we are not going to release you on bail. Where on earth have you seen a bail condition that says you must not address the public? What is that? What happens to freedom of speech? So does that mean I'm not supposed to address in church? Does not mean that one is not supposed to address at a wedding. So effectively, those conditions now are not meant to enhance the bail system, but are actually now meant to put a cage and target particular individuals to then say, when you then get arrested and appear in court, someone will come and say, no, you've breached certain conditions. But these are unconstitutional conditions. You can't have a provision as in a bail order that says someone must not address, someone must not speak. It's actually being released and being told that you must not go and eat. If you eat, we'll release you because you've breached a bail condition. That must not be the case. But what do we have? We have that in Job Sikhala case. Okay, let's suppose Job Sikhala. Okay, let's not talk about Job Sikhala. Okay, enough of Job Sikhala. You said Job Sikhala has breached bail condition. You say, okay, he's been arrested several times. Okay, he's now being bullied because. What about the other people that have been arrested together with Job Sikhala? What happened to the rights of the people that have been arrested together with Job Sikhala? Remember, these are people who have not been arrested before. You know, our law, in terms of our law, murderers, there's actually no exception insofar as the bail application is concerned. Murderers are granted bail. Rapists are granted bail. Treasoners are granted bail. Every offense that is provided for in terms of the Criminal Law Codification and Reform Act, any accused person is granted bail. So you have people, you have Godfrey Sithole. He has no criminal record, okay? He has not been arrested 67 times. It's his first time appearing before the court. He comes to court and you say he cannot be released on bail. But you've got murderers being released on bail. Not to say murderers must be released, it's their right. It's their right to be released on bail, because remember, this is only an allegation to say you've committed a crime that has not been proved beyond reasonable doubt in a court. So pre-trial incarceration, insofar as these alleged offenders are concerned, one would wonder, where is it coming from? When Godfrey Sithole appeared in court, one would have expected his case, his circumstances to be considered as an individual. But what we've observed is that Job Sikhala's case and Job Sikhala's arrest have simply been imputed on Godfrey Sithole. Nothing is being said. If you look at it, you don't need to be a lawyer to observe the thing that I'm saying right now. You look at the judgments that are being delivered in court, you will observe that nothing is being said about Godfrey Sithole. A lot is being said about Job Sikhala, and then at the end of the paragraph, then they'll say Job Sikhala provided, Godfrey Sithole provided transport, and then bail is denied. This is the judgment that we have. But what happened to assessing his case on its own merit? He's appearing in court for the first time. He has not committed any offense. He has not been convicted of any offense before. He needs to have his case determined on its own merits without actually imputing Job Sikhala's issues on him. You look at the Nyatsime 18. These are simply ordinary people. They need to have their cases determined on their own merit. With all due respect, we've got issues in cases of people that have appeared in court. But we know that because of their political affiliation, they've been released on bail. I'll take an example of cases such as that of Obadiah Moyo. You know, someone's being charged, not to convict him, because we are not here to convict him, just like the court is not there to convict people before trial. A serious allegation of 60 million is alleged, and then you appear in court. You are not even, they don't arrest you, they tell you, please come to court. You wear your suit and everything, you look all good, you look all nice and crispy, you come to court. The state does not even impose bail. The magistrate does not even need to make a determination. He simply says, okay, it's fine, bail is not opposed. Okay, it's fine, because we appreciate that bail is a constitutional right. You have Henrietta Rurushkwaya being charged with an issue of smuggling gold. Okay, we're not convicting, You appear in court, the state does not even raise issues. Okay, it's fine, we understand, because there is section 54 subsection 1D, which says bail is a constitutional right. We understand that. But when we have people from Nyatsime, ordinary people coming to court, we expect you to equally apply the law in the same manner. We expect the courts to also behave in the same manner, to say, okay, that's fine, bail is a constitutional right, so let them go. You cannot convict them because they are innocent and proven guilty. What purpose does it serve for you to detain people for 3, 4, 6 months in prison when suppose they come to trial and they are acquitted? Is it not obvious that you would have, they would have been sentenced to Kudara? Nyatsim 13 have been sentenced. Job Sikhala has been sentenced. He is struggling in prison. He has been sentenced already. So what purpose does it then serve to say we will release you after? What then would be the objective of bail if we have this pre-trial incarceration? And the worst part is that the police will continuously tell you that we are not ready to proceed to trial. Our papers are not ready. Our evidence is not ready. Our witnesses are not there, so we are not ready. So if that's the case, why were you arresting in the first place? Do you arrest for the purpose of investigating, or you investigate so that you arrest? Investigating so that you arrest is not being applied to members of certain political parties. Members of the state aligned to a certain political parties, the opposite political party, they are being arrested first before investigation. The person who says, I want to kill Nelson Chamisa and his family, the police want to make an investigation. Okay, it's fine, that's what you're supposed to do. But we expect you to behave equally in the same manner when you arrest people of the opposition. We expect you to behave in the same manner and say, okay, we need to wait for investigation. We must conduct investigation. And when it's right, we will arrest. But we've seen the law being applied in a different manner, depending on the political jacket that you are wearing. We've observed that. So, in short, we now have a situation where the criminal justice system is not being used to serve a purpose that is supposed to serve. We have a situation where the criminal justice system is now being used as a political weapon. This is persecution by prosecution. The criminal justice system is now being used as a system of suppressing opposition voices. I will not be surprised if any one of us is arrested, because that's what the system is all about. That's what the system now is all about. Recently the issue of this this lady who was gunned down by this this gentleman, it has been making it has been trending for the past week. That guy actually appeared in court. He was released on bail, and after he was released on bail, he went on to kill someone. Job Sikhala was arrested. He was released on bail. He never went back to assault people or to kill people, to do whatever is being alleged by the state. He has not done that. And that is not applicable with respect to the Nyatsime 13, because they've never been arrested. They need to be given a chance. They need to be given a chance. So if a son and most of you will know, but I'll protect, I'll not say the names. If a son of a judge who is charged with murder is released on bail, why should the Nyatsime 13 not be released on bail? Is it because it's politically motivated? So you see that our criminal justice system, if I may say, has lost relevance. We no longer have a criminal justice system serving a purpose, except dealing with cases of minor issues. So we need to analyze this thing and appreciate the kind of bench, if not benches, that we have from the magistrates court to the high court. And let me say this authoritatively, the magistrate court is worse. You just go there for procedural purposes. When we go there with political cases, it's guaranteed, it's definitely. Who has ever seen if Opal being granted bail in the magistrate court? Obed, has he been granted bail in the magistrate court? Job Sikhala, you can talk of anyone. As long as there is a political history, no, that person will never be granted bail by the magistrate court. It has lost its relevance. Had it not been procedural, maybe people would simply be going to the high court to apply for bail. But now we now have a situation where almost the same thing is happening in the high court. The bench has been restructured. You know, those judgments, those people, the judges who used to deliver those the so-called fantastic judgments have actually been reshuffled. You now have the bench being constituted by fairly new judges whom, if you can trace directly, you trace their link directly to certain offices and certain houses, which is not what the criminal justice system is all about. So in essence, the fundamentals of constitutionalism have been lost. In essence, the fundamental of the bail system have been lost. Constitutionalism entails having a piece of document which the state must abide by and which the state must respect. But we now have a situation where the Constitution is a mere document. It's only applicable when it's fashionable to use it. You know, I recall when Robert Mugabe was ousted, I remember General Chiwenga raising the Constitution and saying, you know, we want to defend the Constitution. We want to protect the integrity of the Constitution. But you can observe that it's actually being used and observed whenever it's fashionable. When not, as in the case of the arrest, it's simply a document that is being ignored. So we've got this principle of constitutionalism being actually thrown away. We now have a system that completely has lack of respect of the rights enshrined in Chapter 4. The rights enshrined in Section 50, subsection 1D of our Constitution. So we have a very, very serious problem. So, you know, yeah, there have been a couple of cases that I would have wanted to make reference to, cases that have been continuously be mentioned in court. But, you know, I will not go much into that, and I think I will try to breathe for a moment. Thank you for now.
Wow. Thank you so much. Thank you so much, Advocate. Freddie, I'm not sure if it's fine if I can call you Advocate. Okay. All right. Awesome. So, Advocate, I think you really, I mean, we came here, we had a lot to actually ask in terms of understanding all these concepts that you are explaining. and we've learned a lot. And thank you so much for doing this. I mean, we have addressed even most of our questions which we had, and the way in which you presented it, I think you took it straight from the Constitution directly to the constitutional provisions, and even then made reference to the relevant cases and the relevant case law that applies in this instance. And definitely that constitutional right is enshrined in section 50, the right to be released actually on bail pending trial or whatever. I just had a question there when you also mentioned the issue of compelling reasons. If we are to look at these compelling reasons, I just wanted to maybe to put it to you, and maybe you can then confirm for me that we do have, let's say, three particular reasons of which could justify compelling reasons. Firstly, that the suspect is likely to abscond. Secondly, the reason that the suspect is likely to interfere with evidence, mostly by intimidating witnesses. Thirdly, that the suspect is likely to commit further crimes if they are released. Of these reasons, they were compelling reasons. Do you think these are particular reasons that could actually justify the continued detention of the Nyasime 15?
Okay, thank you very much. You can actually not job Sikhala is never absconded tribe. He has always made sure that the decision must lean in favor of granting bail.
Yeah. I was about to ask if you could hear the advocate properly, or he has dropped. I think his network was a bit jumpy. I'll add him back. I see we have Kennedy, we have Smartest there to speak. I'll hand it back to you, Mkomasai. Let me try and add him back. Thanks.
Thank you, my host, Dr. Piti. Yes, colleagues, thank you. As we are waiting for our advocate to come back, maybe you might be able best to also assist me and assist us to understand why is the Honorable Job Sikhala, the Honorable Stole, and all the others who are also in detention being incarcerated indefinitely as we see it happening. This continued detention, is it really reasonable? And is there any particular reason why this is happening? So I see you are back, advocate. You can go ahead.
Every reason that is provided for in the Criminal Procedure Evidence Act as a ground which may constitute compelling reason is not applicable. And let me emphasize that before dealing with a matter, when you sit in court as a magistrate, and when accused persons appear before you, immediately what must ring in your head is to release release the people on bail. So God is interfering. The law says you must prove or provide evidence that these people actually interfered before. And this is not applicable to the Nyatsime Pate because they have been arrested. Secondly, insofar as the issue of causing violence and committing further offenses, the law is very clear again. You must demonstrate that this person was at one point in time arrested and he committed further offenses. This is not applicable to the Nyatsime 15, Nyatsime 13, and it's also not applicable to Job Sikhala because during the time that he was arrested, he never at any point in time commit further offenses. And by commit further offenses, I refer to committing further offenses where you will be convicted. So as long as he has not been convicted, you can't say on record that he committed an offense. You know, because an allegation can simply be made from nowhere to space. It can only be said by the court and concluded by the court that you've been convicted. Then, in terms of abscondment, it does not apply to Job Sikhala. He has never absconded. And it does also not apply to Nyatsime 13. It's their first time to be arrested. And the law is very clear. The court can request their traveling documents to say, okay, we want you to surrender your passport and everything. And remember, more fundamentally, these people have been arrested for the first time. Common practice. First alleged offenders, they deserve at all costs. They deserve to be kept out of prisons. There are reasons why the law say that. We've had judgments that says no. When someone is a first offender or an alleged first offender, it's better to keep that person out of prison than to put him in prison so that he mix and mingles with hardcore criminals. That person is going to come out a different person altogether. You may actually convert that person into a criminal by that pre-incarceration. So the rest of the people apart from Job Sikhala, we should not have been even be discussing the issue of being released on bail. It should have been automatic. And I know for a fact that had this issue not been political, they could have been released. Because that's practice. So all the instances, all these issues that are provided for in the Criminal Procedure Evidence Act as compelling reasons or as issues that the court may actually conclude to say, okay, we are not going to grant this person. They are not applicable in this case either to Job Sikhala or the rest of the people who have been arrested for the first time. They are so the judge said to say, oh no, releasing you undermine the bail system. In what way? That's what constitutional provision. So, you know, considering the fact that people like us are different from people like us, from us ordinary people, they are political people, influential people, and you can expect as many as millions of allegations being raised against them. People like Nelson Chamisa, you can expect as many as millions of allegations being raised against them. So if you then say, because there are so many allegations that have been raised against you, so we are not going to grant you bail, then you create room for the police to abuse the criminal justice system by simply arresting for the sake of it so that they bring in more charges. And then rely on that fact to say he must not be released on bail because he has been arrested several times. That's why it was easy for the police to say when Job Sikhala was in custody, they brought another charge of obstruction, surprisingly emanating from the same fact, emanating from the same circumstances, emanating from the same obviously for incitement. So we want that 49. Anyone wants that person to take, and then you arrest again, and you are emanating from the same was to be used in the system to as many charges as they could take. So all that you raised as compelling reasons, they are, and I say this with absolute certainty, they are definitely not applicable to accused persons.
I can see the co-host has dropped. Dr. PT, can you hear me?
Yes, absolutely. I can hear you. Thank you, Mkoma Shiko, Advocate Fred. Thank you very much for that submission there. And yeah, I've learned a number of things today, thanks to you. And for me, the highlight was the fact that ZRP actually they do not investigate before they come for you if you are from the opposition. It's actually the opposite, So I was actually surprised to know that they know they're supposed to investigate before they incarcerate you, like they're doing for that Mberengwa guy. Thank you very much, Mkoma. I see we have a lot of speakers here. The first one to join was Mkoma Smatters. Please go ahead. Thanks. Mkoma Smatters, are you there? Okay. Okay. If you're there, please go ahead. Thanks.
No, that's fine. When I came up here, we had advocate, what's his name? So I thought Advocate Kennedy. So since we're experiencing some network challenges, I thought maybe you could give him a platform to also give his submission before we can ask our questions. So if possible, Advocate, please accept the microphone. If you could please pass on the microphone to him. We just want to hear his submission. Then from there, we can then have other speakers coming through with questions or with their submissions as well. Thank you.
Thank you. Mkoma Shiko, if you can see him, please do send the mic across. I tested, yeah, I can also see him. Please do accept the mic. Advocate Kennedy, if you can hear us, please do grab the mic and come and give your submission as Mkoma Smatters has said. Thank you. Advocate Kennedy, can you hear me? I don't know. I've sent the mic. I've invited him to speak. And if you can hear us.
Yeah, sure. Maybe while we're waiting for the advocate to come through. Brother Fred, we are having problems with the network, my brother. Maybe if you could, I'm not so sure, when you made your initial submission, I think we were okay for the first 30 or so minutes. So I'm not so sure if you changed your position. So if you could please fix that. We still have so many questions for you. If you could just do that for us, my brother would really appreciate it. I see Advocate Kennedy is here. Thank you.
Thank you there. Yeah, Mkoma Freddy. Mkoma Kennedy, you're welcome. The platform, please go ahead.
Yeah. Thank you very much for allowing me to speak. I'd like to also thank the advocate for the detailed submissions that he gave. That was very, very informative, and I myself also learned new things about the case and going forward. Yes, I know, like, I just wanted to talk about, my own experience with this system, the judiciary system, and to me, what's happening today with Advocate Sikhala, the Nyatsime, and other political activists, it's not pretty much new. It's something that has been there for a very long time. Most probably, we did not want to really observe it, but during the Mugabe era, those things were so prominent and they were so dangerous. If the courts, especially the magistrate courts, if you look at the magistrate courts, the rot that is now there, it's a manifestation of something that has been going on for a very long time. Mugabe, he sowed the seed for this corruption, this lack of observation of the constitution, especially in the lower courts. The system, especially the government, deliberately wanted to make the magistrate courts to be more like a chief's court, like a village court, like Urimu Bes Rezanu PF. That if you get into the magistrate court, there's no way you are going to get out of that system without struggling, even if the law was on your side. I can give you an example of during my time when we were litigating in the magistrate courts. There was a provision within the Criminal Procedure and Evidence Act. I think it was section 121. I might be lost there, but it was a provision which, if you went into the court, in as much as you had the right to bail, in as much as you had the right to be brought to court within 48 hours, the prosecution would just stand up and say, I'm invoking section 121, and you would spend more than 90 days, 40 days in incarceration, and that was lawful. All it needed was the prosecutor just stand up when the magistrate had said, I grant bail. Then the prosecutor stands up and says, I'm invoking section 121. Then bail is then revoked until you appeal to the High Court. I know the advocate is here, he might expound on that, but that was the system back then, and that was brutal until the 2013 Constitution, which then clearly elaborated that everyone has got a fundamental right to bail, and everyone has got the right to be brought to court within 48 hours. But now, as I'm speaking about the rot, this issue of empowering these prosecutors, this issue of glaringly violating the fundamental right to liberty, yangagara iri magistrate court, and it was being nurtured, it was being sowed, and it was being graved into the system in magistrate courts. So to me, when I view the magistrate court, it's just an appendage of the Shek building. Police station. We know the police are polarized. We know the reason why they arrest activists is because they want ZANU-PF to have more space in perpetuating their propaganda. And what about police, the ZANU-PF police, you then get into the dungeon, the magistrate courts, where even if you've got your own constitution, having your own constitution, they've already in structures, already prepared them to deny you your liberty. And the only way you can get out of there is if you struggle. And struggling means getting 30, 40, 50 days of waiting for bail in the High Court. So this is what you are seeing happening to Advocate Sikhala. He's a victim of the system. He's being persecuted by the whole system of governance. The judiciary itself, especially in the lower courts, is non-existent. So the only thing that needs to happen is, as my friend has highlighted, is when we are faced with such situations where an arrest is imminent or we are likely to get into the courts, we need to then exercise, he said, the political eye. Kuti, history has taught us. Kuti, even if Takachema say, and that is just how it is. So when he was speaking, I was saying to myself, but you see, I think we let the system easy. We've got resources. I mean, like I'm in the diaspora, ran away because they wanted to get me because I was representing my client, Zamara, who is still missing today. But I can say I was a coward. I should have stayed on, like what advocate Wiwa is doing. He's soldiering on, defending his own clients. But well, I had to do what I had to do. But the thing is, I mean, I think we're letting this system get off easy. Why am I saying so? I'm not pretty sure of the nitty-gritties or the details on how these our activists are being represented in Zimbabwe. They've got quality lawyers. It is a given. But I think we're still letting the system get off easy. One thing we should not do is to lump accused persons on one lawyer or a group of lawyers. That is letting off the system easy. Each person who has been persecuted and is being brought to court, we should make this system, or we should make the prosecution expensive. Each one of those people who is getting into those courts should have his own lawyer. And each one of those persons should have his own bill application. I got 5 applications from different people. We should not lump our people into one particular lawyer or one particular, law firm, because as my colleague was saying, Kuti, the bill application or bill, what you call this, the bill ruling, taurwa, and go pensira, kweswa honorable MP, 1-2 sentences, because we're making it easy for them not to think, not to really interrogate facts, not to really see what is it's satanic. We have to make sure that each one of the persons are put in court and there is only representation. It might be a situation even if a lawyer won, those people should be represented individually, not Kulampwa all together, because I think that way we're making it pretty much easy for the system to just get away with not observing the Constitution. And I would like to appreciate the content, the depth that the advocate really brought about on the essential elements of the bail and also the issue of the investigation. This I've seen it before. We have seen it before happen. That they just arrest, and when they arrest, they bring the docket to court to the prosecutor, and the prosecutor kuna prosecute. This is what I'm saying. This system is rotten. Kuna prosecutor, that's where kunufa tanga kufira nyaya. Mpulisa wayende docket incomplete. The prosecutor should just say, I cannot get into court with such incomplete docket because hapana nyaya. But they have got the audacity to take an incomplete docket. It's not evidence of any crime before a magistrate. And when they go before a magistrate, the magistrate is being told the docket is incomplete, but he goes ahead and denies bail. That's the system that we have. And that's the system that we need to reform and make sure that we also use certain techniques to make sure that litigation, prosecution is expensive to the system. This is all I wanted to say. Thank you.
Wow, thank you so much. Thank you so much, Mr. Masie, Advocate Masie. Yeah, that was so powerful. I think, yeah, I'm actually writing down some notes here. That individual representation you have given us as a solution in terms of how we can confront this. Maybe just as a quick question for you. I don't see Advocate Freddy. I think he has dropped again. So perhaps you are here as well to assist us. I think most of the people who are here, they would want to ask some questions as well. So I'm not sure if you are also open maybe to actually assist us in maybe clarifying some of the issues. But I just said maybe a quick question to you in terms of, is there any merit in terms of maybe pursuing some civil litigation in scenarios like this, where I'm not sure, perhaps you may advise, is there any perhaps like a provision in terms of perhaps under unlawful detention or prolonged detention, or I'm not sure, what would you say in terms of a private or perhaps civil litigation? Thank you.
Yes, thank you for that question. Sorry.
Okay, sorry. My brother Tino, do you have the advocate on the line?
Yes, I have advocate on the line. So if you want to ask him questions, you can ask him directly. He can hear you.
Okay, thank you so much. Thank you so much for that. Thank you. Advocate Masie, you may proceed, please.
Yes, thank you for very much. So for me, one of the reasons why I became a target with Zimbabwe is because of litigious. And whenever there was a violation of the Constitution or my client had been violated his human rights, I would sue. So there is definitely a provision under the civil law, the civil laws of Zimbabwe, where you can sue for unlawful detention, you can sue for malicious prosecution, you can also sue for torture if they have been tortured in custody. You can sue the state for various, issues that arise from your arrest that emanate from Section 50 of the Constitution. That you can also sue the judicial officer if he acted in a manner that is not, in line with these duties as a prosecutor, either a prosecutor or even a magistrate. For example, if they unreasonably, deny you bail, which is so egregious as to defy, logic or so forth. You can actually sue, the magistrate that way. But that one is very difficult because it's also very easy for them to just say, I was acting within the confines of law. But you can actually do that in terms of the Constitution. So those are provisions that are there, which I always encourage my clients to pursue. Because there's the issue is like, given this situation here, you've got people who have never been arrested from Nyatsime, and right now what the system does is to kill them in terms of their spirits, is to make sure that by the time you're on incarceration, you don't want to have anything with the courts. So you see, some of them, they'll be so happy that they are free, they've been acquitted, and if you talk about pursuing in the civil courts, they will just, won't want anything to do with that because they've been so brutalized by the system, barring incarceration. But here is the thing: fighting this system does not only stop when you have been acquitted. The system on the onset should not have arrested you. That's number one. The system should not have been denied you bail. The police should not have arrested you without reasonable suspicion and without investigating. So you getting an acquittal is not you. It's not a victory for you. It's not a victory for you. The victory for you is when you get those people accountable. It's when you dig deep into the pockets of those people who actually violated your rights. So this is now through the civil litigation. So if you use the civil litigation, you make sure that next time when the police want to arrest you for unlawful or for a crime, they know that they are not going to get what you call this, even for a crime they know is either politically motivated or is just malicious, they will think twice, because they know after this case, these guys are coming for us in terms of monetary compensation or in terms of other compensations that they can get through the civil courts. So the civil route basically acts as an element of deterring such acts. But the reason why Tukona Shiramba escalated is because we have the system breaking our activists to such an extent that the cycle just goes around and round again. That they just do this with impunity because they know kuti apana chichaitika kwavari even if wakakusunga. So we need to encourage our activists, we need to encourage each other to fight on using the civil route.
Thank you so much, Advocate. Thank you so much. I think we do have some questions here coming through. So maybe we also have the Advocate on the line, colleagues. So if you have questions, let's see if we can direct them to our two advocates who are assisting us. And before I move on to the two questions, maybe I just wanted to find out, and maybe I'm posing this question to Advocate. I'm posing this question to Advocate Freddie when he get a chance to respond. I just wanted to find out, in terms of we do have bail being granted, and at times these bails come with conditions. Do we not have enough merits in terms of those bail conditions, or are the courts struggling to secure these people to attend courts, or what is the issue? Or perhaps it is just merely trying to punish these people who are incarcerated. But you can respond to that question. Firstly, let's hear from Brother Max and then Brother Smartis before you respond, Advocate.
Thank you very much, Dr. Sai, co-host Dr. PT, CCC Diaspora, and everyone on the platform. And my question is, as citizens, is there anything that we can do to influence these decisions, these court decisions? What role can citizens play? And I just wanted also to make a comment, say that I heard Advocate Marcia saying that maybe the regime is now things are different. Mugabe was better, but I don't think Mugabe was better, because during Mugabe era we saw that they were actually arresting people and convicting people without enough evidence. For example, last Mnangagwa, I think he already served the sentence of a crime that he never committed. So it's only that the regime was targeting maybe those who were not very popular. But now at this juncture, this regime, it doesn't care. They are now going even for the leaders and popular figures. Thank you.
Thank you. I see also your hand is up. Maybe that question was directed to Advocate Marcia. Please, you can prepare an answer. Host, your hand is up.
Yes. I also wanted the advocates to address the issue of international representation. I think it is one issue that has caused a lot of, or that has grabbed public attention. The issue of the international firms that said they are going to be representing Honorable Job Sikhala. So if you can also touch on that, whether it is possible. Others were arguing that it will be hard to get a license. How does that system work as well to get the international lawyers to come and represent the Nyatime 13? That's what I wanted to add to the questions.
Okay, thank you, host. I think that question, if Advocate Marcia, if you can also respond to that question from the host. My Dr. Smartis, your question, please, directed to Advocate on the line.
Okay. All right. Thank you so much, co-host. Advocate Freddie, confirm you can hear me.
Yes, I can hear you.
Thank you, brother. All right. So, Advocate, I've made these observations as a layman. So maybe if you could please comment on the 4 things that I have observed. One from Honorable Sikhala's case, and all other cases, you go back to Advocate Mahere. You go back to Hopewell and many other cases where we felt that the regime cute, and that's what that
it's arguable, of which I also share the same sentiments. As I said before, Gabe sowed the seed for what we are seeing today, and there's no excuse, therefore, of course, of what the ED system is doing, but the thing is, like, to me, I think they're equally on the same level. If Mugabe was not worse, but I think they are on the same level according to my observations. Then the second one was an issue regarding to international representation, and the questions that were arising from various platforms of whether they'll be allowed to practice and so forth. The thing is, Zimbabwe is a closed, is got a very closed legal system, and of course, for one to come and want to represent someone within the courts, they have to go through the Law Society of Zimbabwe and so forth and so forth. And one other thing is like one issue that we need to then basically look at is what kind of representation is being offered, because from what I observed from what was prevailing on the internet and so forth, I haven't verified whether the representation is true or not, but what I gathered is that the firm wanted to represent advocate Sikhala more on the issue of advocacy rather than the court advocacy, but probably the international advocacy of raising awareness and so forth of his persecution. That's what I gathered. And when I went to the website of the law firm, that is what the law firm does. It helps, on raising awareness on certain violations that are happening to certain individuals, especially their clients, and trying to engage the relevant authorities in trying to conscientize them on those violations. So I'm not very clear on what type of representation this law firm intended to offer to advocate Sikhala, but that is, there are a lot of nuances that are there when it comes to issues of representation, which I've, one of the, is like, they have to go through the Law Society of Zimbabwe. They have to also check in with the Judicial Service Commission or something. So there are a lot of things that go in there, but it's not rare. It's not rare. I know certain advocates from South Africa who come to Zimbabwe and represent their clients. I also know certain advocates who are registered in the UK who sometimes appear within the courts of Zimbabwe. So it's more or less something that happens, but whether it is allowed depending on your credentials is something else. But it's not something unique. It's not something that cannot happen. It's something that can really happen. It's always subject to the approval of the local regulating authority, which is of course the Law Society of Zimbabwe, and other offices that they need to submit their credentials to. So I think on that one, that's my response.
Thank you very much, Advocate Kennedy. Tino, are you ready with the advocate on the line?
Yes, Advocate Frederick, are you ready?
Yeah, sure.
Okay. Yeah, you can go ahead.
Okay, thank you. Let me start by responding to the question that I thought was directed to me of the judicial system under Mugabe and the judicial system under ED. Just to set the record straight, I would not say Mugabe was better than ED, but a specific reference was actually made to the judiciary, and I'll demonstrate why. I agree with my brother, and I think I said that as well with respect to the lower court. The lower court has always been broken, and that's why I even said that, look, if it was practical, we could simply have gone to the High Court straight and applied for bail in the High Court, where you expect at least an independent mind to preside over your issues. But the problem is that nowadays, even the High Court itself has actually lost credibility. The High Court itself is very much now different from the High Court of before. Where we used to have, very good judges, intellectually trained and intellectually proper and everything. Now we've got a different set of judges. We are now seeing direct interference on the bench. Judges, you can now actually trace the political connection of judges to specific political offices. This is what I'm referring to. It's a situation that was somehow different from the situation during the Robert Mugabe. Not, and I emphasize, not to try and sanitize Mugabe. We know the evil regime that that could have been, but it was at least better insofar as one ascertaining the credentials of people who were regarded as fit and proper for the purpose of holding judicial offices. And secondly, they had a little bit of independence and discretion insofar as ascertaining and determining issues were concerned. We know, like what my little brother said, we know the magistrate court has been captured already, and until now it has remained. Until now we know that. But at least during that time, there was hope to say there is a high court. We have some chances, of getting justice at the high court. There was that high court justice hope. That high court justice hope has now been lost. Now, and that is true, because now the decisions that are now being given by the high court are shocking. Read the decision that denied Judicial and got restored bail. It's shocking to a point where I've never seen a judgment of the high court like that. I've never seen a judgment of the high court like that. You can actually tell, even if you're not a lawyer, that this is so wrong. So my point in saying at least there was that discretion and hope in the high court during the Robert Mugabe era. Unlike now, especially in political cases, where you can actually tell that when a certain judge who is known for granting bail is presiding over a case and you've got a political case, that judge is immediately removed. That was not the case, which was not usual or often during Robert Mugabe. But now you can actually have that judge being removed and being replaced by another one. And you can wonder, a specific judge is instructed to deal with a specific case. That surely is not acceptable. So that is what I was trying to say when I was mentioning that at least there was discretion on the part of the High Court during the Robert Mugabe era. Not to say it was better. I'll never say that. But with respect to the discretion of the High Court. Then, secondly, I'll go to comment on the observations that were incorrectly made by a brother of mine who directed this to me. The issue of Reza. Reza, I can certainly say that he is regarded as the political prosecutor. Kurikubora is the number 9 of prosecuting political cases. In as much as I somehow, doubt the manner in which he deals with the cases, because obviously there is clearly lack of independence and professionalism insofar as his handling of the cases are concerned. They regard him as the number 1 person to act, because he is deemed to be the one person that understands the political aspect and politics surrounding this matter. So they just push him forward in the hope that is the one that is expected to appreciate the politics. When you are appointed a prosecutor, just like magistrates and judges, you are expected to be independent. A prosecutor's duty is not to secure a conviction by all means necessary. A prosecutor's duty is to assist the court in arriving at a proper decision of whether or not a person is guilty or not. But what we then have with the Reza situation is that we have someone who is already saying he was guilty with the determination and motive, as if there is an extra check that is coming from a conviction. So we have that person with the eagerness, with the zeal, and who supposedly, presumably, if I put it that way, are expected to understand the politics behind cases. That's why you see most cases is actually put forward. That's why you see last week, or not last week, but there was an application by VP Honorable Tenaki to actually seek for his recusal. When he was saying, look, the manner in which this man is prosecuting my case is unprofessional. The manner in which he's making his submission, making reference, it's unprofessional. He's already, condemning me and saying I'm a criminal. That is not how the work is supposed to be done. Because remember, during trial, we're dealing with an allegation. So you can actually then trace a motive behind certain prosecution, which I think is good for the regime. They want people like that, and I'm sure they want more people like that because they want people with a specific way of prosecution which tallies with their motive insofar as fighting the opposition is concerned. So that's why you see in most cases rather it pushed in the front. Then correctly, my brother, you have observed that the members of Sikhala, and particularly these are with respect to overseers and civic society members, they've been put in court 14 or the regional court. Court 14 in particular is an anti-corruption court. And you have correctly observed. These cases, they are dealt with provincial magistrates. Or in fact, let me put it this way in a layman's language. Ordinary magistrates. They are in a position to actually be able to deal with this case and dispose these cases. But what we have observed is that there is now a specific court where opposition members' cases are being taken to. And this court is an anti-corruption court. And the motive now is actually clear. For them to be able to deny them, they want to create an impression that, look, it was not obvious. There was some sort of reasoning that was happening. We know at the end of the day that there is absolutely nothing. There is no reasoning at all so far as judgment are concerned. But they want to create an impression that there is a certain reasoning that has been applied. So they've got their own experts. They've got their own people who specializes in ensuring that they research about detaining political prisoners. And these are people who, if you direct the cases to, they will sit in their offices, relax and enjoy their food, knowing very well that the person will not be granted bail. There are chances, risk that even if someone, the provincial magistrate simply preside over the issues and, apply law, there is a chance that the person may be granted bail. So, by sending this causes to regional court, there are specific people. Look at these cases. If you want to look at these cases closely, the same people that have been dealing with, you've got the same people dealing with Sikhala case. There's just a few. There's a monopoly of magistrates dealing with Sikhala, Hopewell, Fataima, there's just a monopoly. There's a small number of people dealing with those cases. These are people who you are guaranteed. These are people who have been promoted by the regime. These are the people who are expected to facilitate and push forward the interests of the regime. And these are the people whom you expect, when they've been given a case, you can relax. They don't have doubts. They cannot fear that they are expected taking place. So you have certain people now dealing with this case, but even in terms of the law, it's not proper for them to be transferring cases to the anti-corruption cases when you have actual court that has the jurisdiction to deal with those cases presiding over them. That's why you can even note, if you say, you also look at there was that point that was also raised by over the issue to say, no, why don't you bring this case to this court? Why are you now accepting as the regional court if you now being demoted to lower court? Because this is not supposed to be your case. So it shows they will try to put some reasoning in nonsense. You are trying to justify nonsense by putting some reasoning. Because if you put it to a lay person, you simply know that no, this is nonsense. So they will try to justify that, those decisions. Then the other issue you have observed, and correctly so, is that the use, and I'll call it abuse of the group maximum prison. The group maximum prison is not a remand prison. And each and every time that, you have got our comrades arrested, they are sent to Chikuru maximum prison. You know, the impression that is created, you know, by being sent to Chikuru maximum prison, the impression that is created, the message that is sent out there, the message that the public is supposed to understand is that these people are hardcore criminals. So they want to create that impression. You know, it's a way for them to actually bolster their narrative that these guys are facing a serious case. When in actual fact, there is no case at all. So they've actually then used Chikuru maximum prison to create an impression, and also, you know, in a way, indirectly use that in the mind of the magistrate to say this is a very, very important and serious case, because you can only be checked to the maximum prison when you are a hardcore criminal. You know, job escalation, if you go and see them and see him, you'll be trusty. And even when we see him, you'll be in leg iron, despite the fact that you'll be in the maximum prison, you will still be in leg iron. So the impression that is put to prison officers, to the judiciary, and to other people, you know, who may not be well aware of this issue, is that these are real criminals. And even when they come to court in leg iron, that's the impression that they want to keep. And obviously the other one, like what my brother is saying, is simply abuse. They want to ensure that they break you down. They want to ensure that when they release you, you feel like, you know, something, you know, God has sent you something. You will be happy to such a point that you won't be thinking of anything else but your liver. To say, okay, my way, I survived my leg iron. I survived all the, you know, they want to psychologically torture you, psychologically traumatize you, psychologically break you down to a point where when you are released, you feel like being released is absolutely everything. And you won't even bother to think of everything. You know, to say, I'll go to the civil court. You won't even think of that. Because you are happy that you've been released from something that was actually, they will expose you to certain conditions that, you know, you yourself will say, even if we take someone and say, look, this is what is happening to this, you know, you will literally cry. At one point, I went to see the job, you know, the D class and everything. He's surrounded by a good number of prison officers. He is in leg iron. You know, Job tried in as much as possible to put on his mouth. He tried in as much as possible. But I know Job. I'm always Job, almost on a daily basis. I could literally tell that these guys are trying in as much as possible to break him down. So all these issues, the use of leg iron, the use of Chikuru, it's an attempt to try and destroy the moral, to destroy his spirit, and ensure that, you know, when he's out, he sees the liberty as the main priority. But, you know, job is job, and job is job. So that's all I can say with respect to the observation. And let me say again, you correctly observed it. That's exactly what is happening so far as these cases of activists and opposition members are concerned. That's a correct observation. Thank you.
Thank you very much, Advocate Freddy. I wish if you could see the way the love sign they're coming out and how they are clapping on your submissions. Maybe, yeah. Dr. Pitu and the host. To you.
Thank you, Mkomatino. Indeed, Advocate Freddy, thank you very much for dissecting the law. You know, I was actually commenting on my timeline and saying you are actually like dissecting the law and speaking the truth to power, and it's so simple for non-legal minds to understand. Thank you very much. I'm sure we have a few more questions coming through. We have our speakers. I see Mkoma Champion, your hand is up. I also see Mkoma Freelance there. So I'll just give the ones Vakasi Mtamawoko, then I'll come to the rest of you guys. Just forgive me if it's not the order that you came in. But Mkoma Champion, please go ahead and then right after Mkoma Freelance, then when we get the questions, he'll get a chance to respond. Thanks.
Okay.
Sorry, my brother champion, we can't hear you. I'm not only me.
You can hear me?
We can hear you now.
Okay, I'm saying thank you, CCC Diaspora, and thank you, the speakers, the co-hosts, for smoothing this issue. But within this issue, there is a term which I met when I was just going through, which talks about judicial nepotism. I think I need a clarification on that. Then I also need, maybe if you know the African Charter on human and people's rights, would you be able to explain what does Section 7, subsection 1 says?
Sorry, citizen. Sorry, Mkoma champion. The subsections you are quoting, are they the subsections of the African Charter?
Yeah, because when I was reading somewhere on this issue, I think I find something like that. So I just wanted a clarification to hear if that is consistent with our own. Was it section 50 of the Constitution or whatever? Then also, I don't know.
I think we are struggling to hear you. I wanted clarity in terms of the subsections that you are looking for. Are those the subsections of the Freedom Charter? Sorry, of the African Charter on Human Rights, or what are they? Because perhaps our advocates would want to know exactly which document we are referring to.
Yes, because at the same, I think the same topic which you are talking about is that there is an issue which refers as well to the same, maybe it's consistent with our constitution. So I just wanted to get some clarifications on that. Thank you.
Okay, thank you. The next question, Freelance, please go ahead.
Good evening, guys. Thank you so much for a lovely debate. Probably someone has asked my question. Sikhala, I just wanted to know, if you commit a crime, how many hours are you supposed to be detained by the police? And is Sikhala and company in remand or where are they? Because honestly enough, I think it's coming up to 55 days, and the whichever one that is you are in other countries, you're supposed to be detained for 48 hours. Maybe I might be wrong. Maybe one of them whatever people constitution, which is Zimbabwe in a constitution, which is police indefinite. I am sorry, maybe someone has asked that question, but I would like to know that. Thank you so much.
Thank you so much. Over to you, Dr. Piti.
Thank you, Mkoma Freelance. Thank you for the question. Then Mkoma Champion. I think we can take a third question and then allow the advocate to come through so that he can. Can you just confirm that he got the questions, Mkoma Chino?
Did you hear the questions?
Yes. I'm jotting them down.
Okay. Thank you.
That's good. How many more should it take before you can respond?
Just one more so that I respond comprehensively.
Okay, thank you. So I'll take one more question. Paul, please go through.
I greet you all, my brothers, all protocol observed. Following all the submissions and all the observations that I've made regarding this matter, when I was looking at the stature of like Honorable Sikhala, is it not the case that Honorable is a lawyer? Is it not the case that he's a lawmaker? So why is he being in such a position? So I am forced, or I am persuaded to conclude that we are dealing with a bloodthirsty vampire. We are dealing with a Satanist regime. We are dealing with an uncircumcised regime. My brothers and sisters, this is not normal. If you recall what our former president said, he said the former president, the current president, who is right now, if you wrong him, if you've done something, if you ruffle his feathers, he will not forgive you. Now I can attest that this is what is happening. Ladies and gentlemen, we need to this is a political matter. This is no longer a civil matter, as I can see. My views are that the regime is looking at ways where they can provoke. And now, if the opposition, if we are not careful, and we take into their hands.
Sorry, my brother Paul.
No?
I'm very sorry, my brother Paul. We do have two advocates here who are assisting us to understand. So I'm just hoping that if you can just get to the question, let us ask for the benefit of the advocates who have availed themselves to our disposal. So if you may just ask your question, then we will, if the advocates are gone, we will move over to maybe comments and other analysis. Thank you.
All right, my brother, my sincere apologies for that. So my question is, my views are that this is a political matter. And do we have any channels that we can escalate this matter politically? This is my question. Thank you.
Thank you very much, Dee, for the questions. Advocate Freddie, I believe that you got questions. So over to you. Thanks.
Okay. Thanks so much. The first question is related to African Charter on Human Rights. I hope I got that correct. Yes, indeed. You've correctly observed that there are international treaties on human rights, and you will observe that in terms of our constitution, we've got our chapter 4. It provides that when the courts are interpreting provisions of the constitution, they are also supposed to take into account international treaties, which Zimbabwe is a party to. So in Zimbabwe, we've got a dual system. And, for an international treaty to be binding upon Zimbabwe, the agreement must have been, or the treaty must have been ratified by Zimbabwe, and it must have been incorporated into the law of Zimbabwe. So you need that before an application of an international treaty or convention. Or with the African Charter, it is part and parcel of our law, and the court, in interpreting the constitution, are actually duty bound to take into account the provisions of the African Charter. The same applies to the rest of the provisions, equally the same of the Universal Declaration of Human Rights and all international treaties, which Zimbabwe is a party to, and which we ratified, or rather which we domesticated. So everything that we've been reading about is actually applicable. But like what we've said before, the problem is not with the law. The law is okay. Section 327 imposes a duty on the court to actually take into account that. Section chapter 4 law, I think, insofar as the bail system is concerned, the law is somehow okay. The law is somehow okay, and it is indeed up to standard. The problem is with how it is being applied. The problem is how it is being interpreted. And I want to give you an example of a statement that was made by one jurist in India. You know, he said during the 1960s, you know, we've got a law that is able to stand the test of time, a law that is fit during our times of happiness and during our times of war, a law which is perfect. And if that constitution, if that law is or is not applied correctly, you know, the problem is not with the law, but the problem is with people that are responsible for applying that law. So that is what we have with Zimbabwe currently. The law is somehow okay. It may not be perfect, but with respect to the bail system, it's somehow okay. But the problem is how it is being applied. And we have observed, and I've repeated this several times, there is more politics in the case of Sikhala than law. The case is more political than law. That's why you see that you have, no matter who appears in court, no matter what submissions are in court, a judgment will simply come and say, I'll deny it. There won't be a legal basis and legal justification. So the problem is not with the law. The law with respect to the bail system is somehow okay. The problem is how it is being applied, how it is being used. It is being manipulated. Then, secondly, I think that my brother who raised the issue of the time within which a person must be detained for the purpose of trial. Let me correct you and say the 48 hours does not relate to the period that you are supposed to be on remand. Okay? So the 48 hours relates to the period within which the police must detain you. So when you are arrested, you know, but you don't go to remand prison. When you are arrested, you probably go to the police cell. So in terms of the law, and to be specific, in terms of Section 50, subsection 2 of the Constitution, you can only be detained by the police. You can only be under the custody of the police for a maximum of 42 hours. You must be brought to court within 48 hours. Okay, so this 48-hour provision relates to the detention at the police station. It does not relate to remand prison. Then I move to the question of how long should a person then be remanded in custody at the remand prison before trial. Now, there is no specific time frame within which a person can be remanded. That's the unfortunate part. But the fortunate thing is that you are allowed in law to challenge continued further remand. You are allowed to make an application to say, you've detained me and it's now a certain period of time. You have not tried me. So I want to be released. So there is no second fixed period. But practice, with respect to cases where people are in custody, 1 month, 2 months, depending on cases. Because, for mega cases, I'll give an example. For mega cases, someone can actually be in remand for a period as long as 2 years in remand prison without a trial. It can happen. So it's a time frame that is assessed on, case by case. It is advocated on case by case basis, which I believe that is, when we say our law is not perfect, it's okay but not perfect. I believe that those are some of the issues and the areas which are or can be prone to be abused. Because if you now look at the case of Sikhala in May 15, you actually notice that these guys were not brought to court
there was a full case and witnesses, in other words, what is called a full docket by the police, they were not brought by that. They were brought by what is called at law a request for remand. To simply say, we have reason to believe that a crime has been committed, but we don't know, we don't have enough witnesses, our case is not ready, but give us time so that we do our investigation. So police will still investigate by why the accused persons are in remand prison. So that one defect that the law has to say, it admits or it allows people to actually be remanded in custody, even in cases where there is no focus, there are simply suspicions. So that's the problem that we then have. And also the fact that there is no time frame, there is no exact time frame within which you can be remanded in prison. Again, it's also an issue that depends on the discretion of the magistrate to say, okay, if the person is in custody, the position is that his case must be dealt with, with some bit of agency, the person will be in custody. But also the court, in terms of they will also consider issues as to how complex is the case, the investigations that are being done, is it easy for the police to secure witness and all those things. For which in political cases, that room is prone to abuse. Because you'll have situations where even when you're in prison for 1 month or 2 months, the police officers will simply come and say, we have not yet finished our investigation. And if the person who is presiding over the case is a political motive, you can simply agree with the police and say, the police investigation has not yet complete, so just try and wait a bit until the investigations are actually completed. So which means if the police then come back and say, we did not find evidence, or our investigations did not lead us to what we thought we could bring as a case, you could actually spend time in prison for nothing. So those are the flaws that are now within the law. It then allows for people to actually be determined when the case itself is not ready to be tried. So in short, 48 hours is for detention in the police, but with respect to the detention in custody, waiting for trial, there is no specific time. Each case is ascertained on its own merit. But what our authoritatively say is that the magistrates, the courts are empowered to ensure they give the uttermost agency to cases where people are in remand prison. And in cases where it takes time to complete investigation, they are empowered to, in fact, they are supposed to, in fact, remove the accused person from remand or consider the issue of bail with agents. Because at law, it amounts to a ground for a release on bail to say, I've been in custody, they've not been trying me. So why are they keeping me here? Why should I not be released? Which I know for a fact, in the event that, we'll have an application for bail, it will be a legal ground that will be ready to say, the people have been detained yet, nothing has been happening. So it then amounts to a set or a change the circumstance for the purpose of applying a fresh or for making a fresh application for bail. Then lastly, the question of the political channels, I think that one I'll leave it to politicians. It's everybody who is on this platform to actually look at it and see how best this situation can be dealt with. I'm here to actually provide the only legal aspect. But I'll give you a small insight. Like what I said before, Job Sikhala's arrest, Job Sikhala's case, Nyatsime 13 case, Godfrey Stole's case is more political than legal. It's more political than legal. And when you have a political solution, you must or you cannot confront it with a legal solution. When you have a political solution, you must confront it politically. If you confront it legally, you will miss the point. You'll have predicaments that we have now. Because remember, the law and the court, they are a creature of politics. Judges are appointed by the president. Appointment of magistrates, all these appointments have
difficult for it to control politics. So when you have political problems, they must be confronted with political solutions, because it's only the political solution that can then put pressure on the legal solution. Because if you confront them politically, the people who are responsible for influencing the legal aspect of it are forced to consider, they are forced to rethink and say, the political aspect of it is now dangerous. Can you consider adjusting your legal approach? So you definitely need the political approach. You definitely need the political solution so that you help the legal aspect of the thing to happen. So this is now for the people in politics. This is now for the political leaders to actually sit down and consider. Because the situation is it, the legal issues, they are very, very serious hardness to the legal aspect of it. But the politics, if the politics is properly dealt with, if the situation is confronted politically, whichever way, we are able to put pressure on the people that are responsible for influencing the legal aspect of it. And you may be able to see a very, very quick decision about the liberty of Nyasime 15, and you can actually see them being released. When we sit down, when we relax, because the politics control the law, if you sit down and relax, they'll say, no, the politics is still okay, so the law, let it remain that way. But when they see pressure politically, definitely the legal aspect of it will change. Then, one last thing, if you may allow, I wanted to. Okay, I won't say.
No, go ahead, advocate. You can go ahead. Advocate, you can go ahead if it's. Yes, you can go ahead.
No. Yeah, no. It is good that I stop addressing this one.
Okay, it's fine. All right, let's go. Thank you. Over to you, the host.
Thank you, advocate. I think definitely, we don't want to scandalize the courts or doing anything, but thank you so much. And maybe just to put it in perspective, I totally agree with you. I think the bail system in Zimbabwe, according to our laws, it's actually better than in South Africa, if we were to compare. So, colleagues, friends, family, we are preparing to actually close the space because we've been up for 2 hours now on this episode of Scandalous Wednesday. And we really would want to thank each and every one of you. But before we actually close, we are going to obviously allow some of the last speakers. We've got Amai Kita there. You can go ahead. And then we do have Brother Ndabazezwe. Please, quick questions to our advocates who are here on this platform. We don't take this lightly to have two advocates who are supporting this platform and also providing insight and understanding into especially complex matters such as law. And if it was consultation, we would be owing quite a lot of money. So thank you so much. Over to you, Amaikita, then Ndabazezwe. Please, let's make it maybe in 3 minutes, quick questions, and then we can get the responses. Thank you.
Me. I can't unmute myself. Oh, thank you. Can you hear me, guys?
Yeah, we can hear you.
Oh, thank you very much. My question is quite short. I've been listening to great wisdom and knowledge from the two advocates. Thank you. But there is this case of sub-justice by Tafazwa Mugwadi, who has put on Twitter to say that he and ZANU-PF are not going to allow Sikhala and the other political activists of CCC to leave Kurubi. There is nothing the West or America can do about it. They can't save them now. Yet if a case be pending before the judges, there isn't any decision made now, and we are all anxiously waiting. What does that mean to legally, or to me, a lay person?
Thank you so much, Amaikita, for that. Okay, are you done, Amaikita?
Yes, I am. Thank you.
Thank you so much for that. Brother Ndabazezwe, you can proceed. Brother Ndaba, you are muted. Brother Ndaba, you can unmute. Okay, over to you, my sister Beauty. Are you there?
I'm here, but I don't have a question. I just came to give a vote of thanks to the two lawyers for actually coming here and speaking to us and answering our questions and enlightening us with a lot of facts. Thank you.
Much appreciated. Thank you so much for that. Brother Champion, you can go ahead with your closing remarks.
Thank you so much. Thank you so much. I don't think I can add more since my Andy Beauty has said you have already thanked them. So let me pass it to someone else. Thank you so much.
Thank you so much, my brother. My brother Max. Thank you very much, Leader Sai, Dr. Piti, and to our learned advocates. Thank you very much for gracing our Scandalous Wednesday and also shedding some light. It's very unfortunate that we have a rogue regime there, a justice system that is captured. Thank you very much. We hope for the best. And like I said before, I think I didn't hear the answer to say, as citizens, what can we also do so that we pressure or we have an effect on these rulings by this court? Did you hear my question, Leader Sai? Oh, sorry, please repeat your question. Okay, my question was, as citizens, what can we do so that we actually influence these judgments by the judges? Is there anything that we can do as citizens? Awesome, thank you so much. I think our advocates will touch on that as they give their closing remarks. My brother Tino, your closing remarks.
My closing remarks. I think my question was already asked by Amaikita, because I see most of the Warakashi also vying for those same sentiments, and we saw that one for who wanted to, who is with the famous one called the goat thief. He also made some statements like what Amaikita was saying. So I just wanted to say, is that not actually a bit of more political interference, especially on the case which is on the courts, especially with the high-profile people, which are considered, some of them, as civil servants as well. So is that lawful to do such insinuations? That is my other question that I also wanted to just pose, and also to thank the two advocates that grace the space today. It was actually very formative. Just wanted also to thank them.
Okay, thank you so much. Sorry, apologies for that. I think there was a new request for speakers. Oh, Brother Washington, Leader Washington, you can go ahead.
Thank you so much for allowing me to speak. The hosts, co-hosts, all the dignitaries, advocates on the space, protocols observed. This case, I take it so personally. That's why I just thought I would perhaps speak or have one or two words. It's been such an insight in hearing submissions from Advocate Freddie there, Brother Tino, and Advocate Kennedy there. I think the possible question that I have myself is perhaps it was asked in a different way. What I've seen or observed in terms of the political interference that's been done by ZANU-PF is that it looks like Mugabe is coming in now, but prior to this, I think it's been Nick Mangwana, or before it would be other leaders who would make some comments in either press conferences or in any meetings about a certain situation. And if a case is being dealt at court, whatever comments that they make, it basically then means that whoever would have done something is now being on the hunt by the police and they'll be arrested. And the interference that Mugabe has done, basically trying to say there's no jurisdiction for the international bodies or America. I think it was mentioned that Zimbabwe is a signatory to some of these laws, rules and regulations in adherence to some of the charters. And as such, if people can, civil servants can now then coming up in Twitter spaces or in spaces like this and utter like that, what is it that can be done? I know it's a political interference, but my question is, what is it that can be done? I'm now asking those within the legal fraternities, our advocates on the space, what is it that can be done to expose people like that, and to also expose perhaps gathering all the utterances that have been done by the ZANU-PF leaders, especially when something has happened, they go and either do press conferences, people are arrested, or when people are in court, they make utterances, and then when they're supposed to be released, they're not released. It looks like the courts will take the narrative that would have been said by these people when they speak or when they leave messages, either on Twitter or in their press conferences. That's my bit, but I really want to appreciate such debates, and I also want to appreciate the amount of work that we are doing. I'm going to go to my brother, Freddie. Thank you so much for the work that you are doing. We need to continue working together and make sure we do even more, because you are in Zimbabwe and you are able to buy food for these families. I really, really, truly appreciate that. My brother Kennedy and my brother Tino, I can't say more. The amount of work that you are doing, petitions, you name it, I can only say thank you. And everyone who's here, the scandalous team, I'm not going to come back. That's why I'm just saying my remarks. And perhaps so that I don't then get lost in my utterances, I'm going to give my mic back. But I really want to appreciate. I don't know if I can get an answer to that.
Thank you so much, Leader Ali. Thank you so much. Mama Teo, I think you came in. I think you can have your say.
Oh, thank you very much, Dr. Pitt. Thank you, CCC Diaspora host, Psycho host, and all the citizens and everyone on the platform. I want to appreciate you guys for venturing into this area because it is an area that is a bit problematic, but by tackling it, at least that will be the beginning of getting a solution. And I also want to appreciate the legal minds. I'm not going to answer some of the questions that have been asked. I'll leave them to you. But I've got really what I have is not a question, but I've got a comment. Say that if as Zimbabwean citizens, if we don't change our mindset, if we believe we are actually working we've got a normal situation in our country, then we haven't started to look for a change in the way things are done. What we should understand really is that we've got a government, a ruling party rather, which calls itself a government, which wants to retain power at any cost. And therefore, this is why they can afford to be very careless. They can afford to do the opposite of what is expected, even at law. Because to them, they are everything. I think sometimes we don't listen very carefully. I remember listening to a video where President Mnangagwa, as president of the country and the president of ZANU-PF, was saying that we are everything as ZANU-PF. But if we don't believe that, then we should actually believe now, because what we have been seeing recently shows that they call themselves everything, and that's why they're doing whatever they believe they want to do. They don't care, and this is why they don't even care about what the international community thinks or does. Because for them, you would want to believe they are trying to Zimbabwe to do the Zimbabwe is open for business and let FDI come into the country, but when you closely look at their action, it tells you differently. So I think let us look for solutions, but realizing exactly where we are politically. Thanks.
Thank you so much, Baba Mateo. We appreciate. Maybe Brother Tina, if you can confirm if you still have our advocate there.
Yes, he's still on the line. Advocate.
Okay, all right, thank you.
Yes, I can hear you. Okay, yeah, thank you.
Okay, maybe before we go to Advocate Freddy, we can start with our Advocate Kennedy Masie. Please, Advocate, your closing remarks.
Thank you very much. Probably I'll just stick to the point that one speaker said or asked about what can we do. Well, for me, I can always think of legal ways of asserting your rights, in as much as the systems are basically what we don't envisage as transparent and so forth. I believe the more we use those systems and expose them, the more we create a track record on how the law or the judiciary itself is weak and is captured. Going to the fact of how can citizens do, or what can citizens do, or probably what can they do, or probably utilize going forward. There are various mechanisms within the law in Zimbabwe. The Constitution of Zimbabwe, basically in Section 85, subsection 1, elaborated the issue of access to justice and access to courts, and also local standard on who can bring a case before the courts. And basically, there's a provision within the Constitution that basically allows anyone who feels that they want to protect rights of a third party or someone else to bring a case before the courts. So basically, you don't have to be the one who has been violated in terms of your rights, but you can actually bring a case on behalf of a certain group of people or and so forth. So there's a provision within the Constitution that allows people who are grieved by what's happening to fellow citizens to actually bring a case before the courts. So this Section 85 is a good starting point where if there are people who come together and feel that they want to challenge, let's say, the manner in which the discretion of the manner in which the magistrates are giving their discretion in terms of the bail, which is in contravention of the Constitution, it's something that can potentially be a case within the constitutional courts or even the high courts. And even within the high court itself, there are provisions within the high court rules which talks about public interest and also social action litigation. And these are some of the provisions, of course, with the consultation, with consulting the lawyers on how best people can come together and challenge specific types of litigation, the specific types of laws or specific types of actions within the system itself. Some might say, I know the system is captured, but for me, the reason why I kept on, litigating, I was so litigious, litigating was to make sure that, you create this posterity. You also create this issue where there will come a time where these judges will be embarrassed, by the way they are pronouncing these judgments and so forth. And there will come a time when, where we can then look back and quickly rectify or fix some of those areas that we are crying out about today. But we cannot quickly do that when we ourselves don't want to assert our rights using the mechanisms, even though few that are there to make sure that we bring these people to account. And also the issue of civil litigation, litigating and suing individual police officers is something that is a strategy that can be used. I know, under our laws in Zimbabwe, there's an issue where if a violation happens, let's say if you are tortured by the police, you want to sue the minister of police, you want to sue the police officers themselves, individually and severally, and just blanket them into, a case where you're suing the government. We can use, I know some lawyers are doing that and some people have been doing that. We can use a certain, mechanisms where instead of suing the whole institution, we go for the individual police officer. Tomu seva masamon zake argu Glenview ko argu gareko. Tomu seva masamon zake argu Bodiro ko argu gareko. Then if the case goes to court and there's clear evidence and if a civil judgment is given, $10,000 in compensation, we go and take zima properties, zima sofa zake zozo, chimba chake chochoto chatacha, and so that we make an example, connect those people who are supposed to be protecting citizens, that iwewe, in as much as you are in your glad uniform, if you do this, we're coming for you and your family and individually. Tisina kana kuti mpulisa kana kuti uchaseva na officer in charge or even the whole system we're coming for you individually, and this in itself will create a situation where we dissuade such actions going forward. So this is what I just wanted to contribute. Thank you.
Yeah, wow. I'm sold. I'm sold, advocate. I think we will be in your inbox. Yeah, we are sold to this idea. I think it is the way forward. I think our Scandalous Wednesday team will be in touch, and we definitely have to do something regarding this. Over to you, Dr. Pete.
Thank you, Brother Saibi, and thank you to our advocates for coming through. Inini, I've learned quite a lot, and of interest is that Tadizo Guti, ZANU-PF, police, CCC police, and we remember the set is ZANU-PF, I think. So they investigate. They actually incarcerate you to investigate, as opposed to to doing the opposite. They're supposed to investigate so they can incarcerate, but that's what they're doing to our opposition leaders. And also, thank you for teaching me that the High Court hope for justice has been lost. Indeed, it has been. And thank you very much, guys, for coming through. It was an amazing space because of your expertise. Thank you. I'll hand it over to you, Advocate Freddie, to give your last remarks there. Thank you.
Thank you very much, Dr. PT. Well, in closing, let me say that we are confronted by a political problem, and the legal remedies, in as much as there are many, it is the politics that is supposed to be at work. In fact, it is the answer to the question that what must we do as citizens to also put pressure on the legal side. And it is the answer to that question that will bring a solution and an end to the problems that we are seeing from the incarceration of Job Sikhala in the Nyatsime 13. Job Sikhala in particular was arrested for doing his job. I'm happy Mr. Ali is here. He said something. Job Sikhala is being arrested for demanding justice, not only as a member of a political party, but as a legal practitioner, which is perfectly entitled to, not only in terms of the Legal Practitioners Act, but in terms of the Constitution. So we have a statement that is actually being made there by the regime that by whatever means necessary, they will try in as much as possible to silence the voices of anyone who can actually want to stand up and demand justice, which is what Job Sikhala did, resulting in the arrest of the other 14 that he was arrested with. It's a clear sign that we have a system that wants to thrive in darkness. So many issues surrounding the death of More Blessing Ali, may so rest in peace. So many issues that need to be investigated, inquiries need to be made, exposures and discoveries that need to be made. But because someone actually stood up and said, we need to make an inquiry, we need to put an end and demand justice to this case, he is detained in prisons. Many of the people that associated with that person are detained in the prison. Clear proof that we have got a regime that thrives in darkness, that has no interest in transparency, that wants to do its dirty deeds, that don't want to be known and exposed. So it's not an issue that we can sit down and solve by papers, and good language and good English in court. But it's a struggle that needs a political solution, and it's a political solution that can only come from us or you, the people that are on this platform, as citizens, to say, let's stand up, let's take action, let's speak, let's also ensure that we make a statement so that we confront the political problem with also a political confrontation to ensure that the legal aspect of it is actually okay. I think that will be all in my closing. I thank you for inviting me here. It's actually been a pleasure to interact with you for the past 2 hours. I'm glad I had this opportunity, and fortunately for us, Majesano and most of the times here, but luckily and fortunately, Maranga, God is in it, unfortunately, so I managed to, sail through. So thank you so much, guys. Thank you so much for inviting me.
Thank you very much, advocates. Indeed, God is in it, and we really appreciate your time. We appreciate your expertise and you taking time off to actually share with us all those insights. And guys, I would like to appreciate everybody on the platform to just say thank you so much for coming through to the space today. So this is Scandalous Wednesday, guys. We meet every Wednesday. We are unpacking the scandals by ZANU PF. You know, ever since 1980, we're talking about what they've been doing, you know, so unpacking all these scandals. And today we were graced by the presence of two advocates in the house. We're talking about persecution by prosecution. So before we close the space, we're just going to yield the mic to our director. Dr. Smatters, over to you. Thanks.
Thank you so much. Most importantly, thank you so much, listeners, for coming through to this space. I really appreciate you. CCC Diaspora Desk, thank you for hosting us. To my learned advocates, we just want to appreciate you. Thank you so much. So today, this episode of Scandalous Wednesday, we're looking at the Nyakime 15, right? And also we looked at Honorable Sikhala. I think from our discussions, we picked that Honorable has been arrested for close to 67 times, if I'm not mistaken, but he has never been convicted of any. In many cases, have actually failed before reaching trial. So we just want to thank Brother Freddy there. Brother Freddy, I wanted to ask you a question as we are closing, because when you came through, the submission that you made, my brother, I'm so proud of you, and also looking at the amount of work that you are doing back home, be it informing us on what is happening at the courts, visiting Honorable, the Nyakime 15, and also the philanthropic work that you are doing, buying food for people, then the register to vote campaign, where you are having to use your resources. My brother, you know what? For me, I go to church. So usually what we normally do is, after a message like this one, we sow a seed, just to appreciate and thank God and say, hey God, thank you so much for the revelation, and thank you so much for ministering to our lives. So I'm going to do this, my brother. I would love to partner with you in terms of the work that you are doing in Zimbabwe, be it buying food. So I just want to ask you, my brother, if I do have people that would also want to join you in this noble quest to impact, the lives of our fellow Zimbabweans positively. What is it that we need to do to make sure that is there? Do we have a GoFund link? Is there a group of partners, people like me? I was going to say Scandalous Wednesday is going to put something aside, a donation. I'm so tempted to say we need to make a pledge maybe for $1,000, just to try and buy food for the Nyakime 15, those families. Because us, what we believe in action. We don't just come for Scandalous Wednesday. We expose these scandals. We also try to come up with action points. So I'm very much tempted to say, my brother, we need to set aside $1,000. I know it's achievable. So maybe what you need to do is, if you could give us a platform. If Scandalous team cannot deliver on this one, I can take that one on my shoulder. I will look for other sponsors or other partners to come through. 1,000 and once off, but in terms of long term, you are one person that you have demonstrated to us in terms of action. I've been observing you, I've been following you on Twitter in terms of the updates, not just that, the transparency, the communication. It looks like you went to the same school, now, Brother Freeman Charlie. So I just wanted to say thank you so much, for coming through to Scandalous Wednesday. Just as a way of appreciating you, I'm also involved in some charity work. I know my sister, Dr. Diamond, and many other people that are on the platform, they are involved, in charity work, when you look at what's happening, in Zimbabwe. Man, I would love to work with you. It's always good, when you work with smart people. Maybe those are person around are smart. So what is it that we can do, my brother, if you want to partner with you, retail partner or advocate? Brother Fred.
So much. Okay,
Brother Smarters there. Unfortunately, Brother Freddie is just dropped, but I managed to reconnect him and give him a feedback of what you were actually saying, to say we need to also partner with him, especially as Scandalous Wednesday, to contribute with the philanthropic work that he's doing. I think that is the main that you are actually saying there. I'm not sure if you can maybe just summarize it to him as well, so that he can...
No. Okay, yeah, sure. In short, Brother Freddie, I don't wish to waste people's time. I personally would love to partner with you. I've been observing you, the work that you're doing on the ground.